Good day, my name is Axel Tandberg. I am a GDPR expert at LegalWorks Advisory. We are a business law firm that deals with a lot of companies and their in-house lawyers. Among my clients, you find a lot of those who deals with GDPR and marketing issues, so data-driven marketing is close to my heart. For my clients who works within data-driven marketing, they're facing quite a few problems now with the GDPR and the implementations of it. The main issues are the questions that there is no safety or security and progress within how to deal with in collecting data and ensuring that the data is collected the correct way, and what tools to be able to use, because we are changing the view of whom and what tools we can use from which countries and how so it's been doing. There's a lot of insecurity, therefore, on how to act, and therefore they decide not to act on data-driven marketing. One of the problems that we see now in Sweden is actually the issue of transferring data to the US. We have a big problem now that we're not able to use American services, which is one of the major problems for a lot of companies, which is, you might say, that's not a problem, just use a European one. Well, there aren't as many European alternatives that are as good enough or as well equipped enough as the American ones. For instance, if you want to use a cloud service provider, the European ones that are out there are not as advanced and helpful as the Americans are for the moment. As we all know, the Americans have been trying to, we locate the data within Europe, we're trying to do everything we do about that. And then you have the problem that there is a possibility that it might be an American authority might, for instance, if you have a microscopic chance that it could come, and then you're getting a fine for that. We have a big problem with this. Well, the major problem when it comes to data-driven marketing and consent and legitimate interest is the misunderstanding that you need consent for all the processing you need to do for starting your marketing. There are needs for consent for certain parts of digital marketing, but not for all the parts of dealing with marketing. This is creating confusion within the companies and their ability to act. Thus, the GDPR has not created the clarity that we thought it would do. If you want to work with legitimate interest, I always tell my client that you always need to inform the data subject, and you have to inform them in a manner that they can understand what it is. So always make sure that you're mentioning it in a short and easy understandable text with a link to the full data, to the privacy notice, where you've explained everything what you're going to do with it, and ensure that you're doing it in the right way and that you have informed them there, because information is the only reason and the only way you can move forward here. When it comes to the information, you can sometimes say that, this is information not being read by anybody. But the issue here is that, yes, it might not be read by everybody, but it's read by somebody, and you have to ensure that these come through. And you can say that, this is too complex. That's why you need to write it in a way that is understandable. And you always have to go back to yourself. I always tell my clients, go back to yourself and read it and write it in a way that you could understand. You can give it to your grandmother, that she would understand what you're doing. This has been my advice for the last few years, but the problem is now that the authorities are saying that that is not enough, that's not clear enough, which means that we now are in a problem of writing a third version of the privacy notice, which is more technically advanced, and technically it's getting harder and harder for the consumer or the data subject to understand. So it feels like we're writing first an information for those who are sort of, I want to use your services, and I can understand what you're doing, and here's a link to where I can read more. Perfect. Then there's those who go through that, and then you want to have another link where you have to have for the regulatory authorities to say, this is exactly how things are working within my company. So this is creating a lot of problem for my clients, because they want to be using legitimate interest. They've been using it, and here in Sweden, we've been using it quite a while. We're fairly used to it. But now the information demands are getting higher and higher and more complex, which creates a problem for the data subjects. What my client needs is clarity, and the only ones who can give clarity are the regulatory authorities within Europe, the EDPB, etc., and all the others. What we need for them to do now is to come out and state once and for all that you may use legitimate interest for marketing, and you may use it for sharing your data with a third party, as long as all the rules of compliance and everything that's behind legitimate interest that you need to do prior to sharing and marketing are you done that, then you can do that. But what we need now is clarity, because uncertainty creates a void, and a void which means that we're not doing anything, and marketing is, they don't dare to market, and then the projects are not coming to market, etc. And we're going to get only focusing on the protection of the data subject's integrity. While we should remember that the purpose of GDPR are twofold. There's one, to protect the integrity of the individual, but also to create, to sell and be able to create business opportunities with data. So it's time actually for the authorities and the rest of everybody to realize that for a thriving European businesses, we need to be able to use the data, and we're hoping for a more positive view on that. And can only pray for that.